Article 250, Sub-Article 1 could not lawfully be performed by the Secretariat alone. And second, that the clearance process was consequently a nullity that fatally infected the nomination. The respondents, however, maintained that the midterm replacement mechanism under Article 149, Sub-Article 1, was a sui generis self-executing constitutional process that did not engage the IEBC electoral mandate under Article 88, Sub-Article 4, and that the strict eligibility and clearance protocols under Articles 99 and 137 applied exclusively to general elections and not to midterm nomination vetted directly by the National Assembly. Our reading of Article 149, Sub-Article 1 confirms that it is unambiguous, express, and self-contained. It establishes a strict executive legislative process where the President nominates and the National Assembly votes on the Deputy President nominee. It makes no reference to IEBC. That omission is not an oversight. It is a deliberate constitutional choice which this court must give full effect. Were it the intention of the drafters to impose a more stringent requirement, nothing would have been easier than to say so expressly, as they did in Articles 99 and 137 in respect to candidates for elective office at a general election. The absence of any equivalent requirement in Article 149, Sub-Article 1 is therefore a considered constitutional choice to be respected. For ease of reference, Article 149, Sub-Article 1 provides as follows, and I quote, vacancy in the office of Deputy President. Within 14 days after a vacancy in the office of Deputy President arises, the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. From a plain reading of the above, we are convinced that no clearance was required by the Deputy President, and that the vote by the National Assembly was an expression of representative authority by the sovereign's elected representative, precisely the constitutional mechanism that Article 149, Sub-Article 1 contemplates. Under Article 1 of the Constitution, sovereign power belongs to the people of Kenya and may be exercised either directly or through their democratically elected representatives. When the National Assembly voted on His Excellency Kindiki's nomination, it did so as the constitutional repository of delegated sovereign authority acting on behalf of the people in accordance with the specific mechanism the Constitution provides for filling in a midterm vacancy in the office of the Deputy President. We equally accept the respondent's submissions that on the deliberate use of the word vote in Article 149(1 as opposed to the words approve or vet that the Constitution employs in other contexts. That distinction is constitutionally significant. Across the Constitution, we note that the word approve is used where Parliament exercises a confirmatory function in relation to executive appointments, as in the approval under Article 132, Sub-Article 2 of Cabinet Secretaries, the Attorney General, the Secretary to the Cabinet, the Principal Secretary, the High Commissioners, Ambassadors, and diplomatic consular representatives, as well as any other state or public officer whom the Constitution requires or empowers the President to appoint or dismiss. The same applies to the approval of the candidates for constitutional offices such as the Chief Justice under Article 166 of the Constitution. In those contexts, approval connotes a deliberate and structured vetting exercise in which Parliament assesses the suitability of the nominee against a prescribed criterion, and in which the IBC or other constitutional bodies may have a role to play in verifying qualifications. The word vet carries similar connotations of structured scrutiny against defined standards. The word vote, by contrast, denotes a direct and immediate exercise of collective democratic will. It is the language of elections and of sovereign determination. Its use in Article 149, Sub-Article 1, signals that the National Assembly's function in the midterm replacement process is not to sit in the judgment of the nominee's suitability, but to exercise on behalf of the people a direct democratic determination on whether the president nominee should fill the vacancy. That determination is political and representative in character, and it is expressed through the ballot of elected members of parliament, each of whom is accountable to their constituents for the vote they cast. It consequently follows that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149(1). The absence of any IEBC involvement would not have rendered the nomination or the filling of the vacancy unconstitutional. The informational input by the IEBC Secretariat did provide was, in those circumstances, entirely voluntary in character. It was not a condition precedent to the validity of the process, and its presence or absence was constitutionally irrelevant to the outcome. That being so, the fact that the input was provided by the Secretariat in the absence of commissioners is equally irrelevant if the input was not required at all. The question of whom within the IBC provided it simply does not arise. For completeness, however, and to the extent that any residual question remains about the lawfulness of the Secretariat's involvement, we are satisfied that the informational verification performed by the Secretariat could not have constituted a clearance in the electoral sense, but rather a routine administrative task, and as such not constitutional or policy-driven. The same was legally permissible and procedurally valid and fell squarely within the Secretariat's lawful administrative mandate. We draw from the advisory opinion number 4 of 2024, IBC, and the Honorable AG, where the Supreme Court gave guidance on the dichotomy that exists between the role of the commissioners and that of the Secretariat in the following words. And I quote, "The Secretariat, under the leadership of the Commission, Secretary and the CEO, is empowered to undertake routine administrative and operational tasks essential for the day-to-day functioning of the Commission. In the same vein, it is necessary to clarify that the absence of commissioners does not of itself vitiate or invalidate administrative actions taken by the Secretariat within the scope of its lawful mandate, including the execution of contracts, management of personnel, procurement, and other functions necessary for institutional continuity. Such acts remain valid and binding, and provided they fall within these bounds of statutory delegation and do not purport to usurp the constitutional function of the Commission as a corporate body," end of quote. To guard against institutional overreach, the Supreme Court carefully delineated where IBC's administrative mandate ends as follows, and I quote once again, "Having concluded as above, a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It is our considered view that the exercise of constitutional function expressly reserved for Commission, such as those enumerated under Article 88, Sub-Article 4 of the Constitution, cannot be lawfully discharged in the absence of a properly constituted Commission with the requisite quorum as contemplated under Article 250, Sub-Article 1 and Sub-Article 2 of the Constitution," end of quote. This differentiation of responsibility is further contained in Section 11A of the Independent Electoral and Boundaries Commission Act and exposed by the Supreme Court in the Muruli versus Oparanya and 3 others case. For all these reasons, it is our finding that the Secretariat did not travel beyond its mandate. It simply functioned as an information repository. Having so found, We now move to the last sub-issue concerning the constitutional validity of His Excellency Kindiki's nomination. The petitioners anchored the ground on Article 148, Sub-Article 1, read with Article 137, contending that His Excellency Kindiki was serving as Cabinet Secretary for Internal and National Administration, a state office under Article 260, at the time of his nomination and parliamentary approval on the 18th of October 2024. He was disqualified from nomination by dint of Article 137, Sub-Article 2B, rendering the entire process null and void ab initio. In contrast, the respondents who responded to this ground argued that the appointment process was completely legal and procedurally sound. They maintained that the filling of mid-term vacancy under Article 149, Sub-Article 1 was an independent sui generis executive-led process, and that was distinct from traditional election or appointment. Further, it was the case that the restrictive disqualification in Article 137, such as the recruitment to the requirement to resign 6 months prior to or to secure multi-county voter endorsement, were tailored exclusively for general elections, not sudden midterm vacancies that demanded swift action to prevent a leadership vacuum. They contended that the initial formation of a presidential joint ticket under Article 148 could not apply to midterm emergency transitions. In addition, His Excellency Kindiki and the IBC specifically disputed the factual basis of the petitions, arguing that His Excellency Kindiki had in fact provided official gazette notices proving he had formally resigned from his cabinet position prior to his appointment as Deputy President. In considering the arguments of both parties, we turn to the relevant constitutional provisions, to wit Articles 137, 148, and 149. Article 137, Sub-Article 2B, bars any person who is a public officer or is acting in any state or other public office from nomination as a presidential candidate. Article 137, Sub-Article B, carves out exemptions for the sitting president, the deputy president, and members of parliament. Cabinet secretaries are not included in that exception. Article 148, Sub-Article 1 also locks the qualifications of a deputy president candidate to those of a presidential candidate under Article 137. And Article 148, Sub-Article 2 provides that there shall be no separate nomination process for the deputy president at a general election. Article 149, Sub-Article 1, however, creates an entirely distinct pathway of filling a mid-term vacancy, as we have already observed, through a direct presidential nomination followed by a National Assembly vote. It makes no cross-reference to the electoral machinery or disqualification timelines that apply under Articles 137 and 148 in the general election context. A strict textual reading of Article 148, Sub-Article 1 and Article 137, Sub-Article 2B together would, if applied without contextual qualifications, bar an active cabinet secretary from nomination unless a timely resignation had occurred. However, we are satisfied that Article 149, Sub-Article 1, creates a sui generis process that cannot be evaluated by mechanical application of the general election framework. Article 149, Sub-Article 1, omits the standard electoral requirements, including the signature collection requirement and Article 137, Sub-Article 1D, which signals the framers' intention that this provision operates independently of the general election machinery. To apply the strict disqualification timelines of the electoral context to a sudden or unforeseen midterm vacancy would risk creating an executive leadership vacuum of precisely the kind that Article 149, Sub-Article 1 was designed to prevent. In any event, we are satisfied that the factual premise of the petitioner's challenge is not established on the evidence. The primary constitutional mischief targeted by Article 137, Subarticle 2B, is the prevention of active public servants from deploying state resources or conflicting institutional mandates to influence an election or appointment. The evidence before this court establishes that despite the unique circumstances of his nomination, His Excellency Kindiki formally resigned from the cabinet and gazetted his exit prior to taking oath of office as Deputy President. By severing his ties to the cabinet before assuming the Deputy Presidential office, the potential conflict of interest under Article 137, Subarticle 2B is designed to address was lawfully cured. The core integrity parameters of Chapter 6 and Article 137 of the Constitution were accordingly satisfied. This ground of challenge therefore fails. Before concluding on this issue, we must address whether the speed with which the state resolution, with which the Senate resolution was gazetted, the President nominated Professor His Excellency Kindiki, and the National Assembly approved the nominee, contravened the Constitution and the law. The petitioners argued that the extraordinary haste following the Senate's resolution of 17th of October 2024 revealed a predetermined impeachment process. In their view, the immediate gazettement, swift presidential nomination, and expedited parliamentary approval were evidence of a pre-arranged outcome. They contended that such speed undermined constitutional values of transparency, accountability, public participation, fairness, and constitutionalism. The respondents, including His Excellency Kindiki, took the opposite position. They maintained that the Constitution itself anticipates expedition in matters concerning high constitutional office. Once a vacancy arose in the office of the Deputy President, they argued the President was constitutionally bound to act under Article 149. Prompt compliance with such a duty, they insisted, cannot be itself amount to constitutional impropriety. Turning to the Constitution, Article 149(1), we have already reproduced that section, that article. I don't need to go through it again. Proceed. This provision leaves no doubt that the framers of our Constitution deliberately contemplated speed in filling in a vacancy of the Deputy President's office. The rationale is evident, and it is to safeguard continuity and the stability in the national executive by requiring prompt action. Judicial President reinforces this principle. In Ali Hassan Joho and another versus Suleiman Said Shabal and others, this is a Supreme Court petition number 10 of 2013, the court held that constitutional timelines are substantive requirements, not procedural conveniences, and cannot be extended by legislation or judicial discretion. Similarly, in the Mankin Aramat versus Harun Meitamei, Lenpaka, and two others, the Supreme Court, it's a Supreme Court matter petition, the court emphasized that constitutional timelines are binding commands, cautioning against reliance on Article 159 to circumvent them. The same principle was affirmed in Moses Masika Wetangula versus Muskari Kombo, Muskari Nazi Kombo, and two others, and in Harun Meitamei Lempaka versus Lempakian Aramat, where the Court of Appeal underscored the constitutional significance of timelines. Collectively, these authorities highlight that timelines serve vital public interests, including certainty, legitimacy, and orderly governance. The Supreme Court's decision in Raila Odinga and 5 others versus Independent Electoral and Boundaries Commission and 3 others, this is presidential petition number 5 of 2013, is also instructive. Addressing timelines under Article 140, the court had the following to say, and I quote, according to Article 140 of the Constitution, it is clear that in the resolution of presidential election, disputes, sorry, I repeat that. According to Article 140 of the Constitution, it is clear that expedition in the resolution of presidential election disputes is of essence, end of quote. The court warned that prolonged uncertainty regarding the presidency undermines public interest. This reasoning reflects a broader constitutional philosophy that uncertainty in the occupants of high office is detrimental, and the Constitution deliberately establishes mechanisms to ensure continuity. Applying these principles, we are not persuaded that the prompt gazettement of the Senate's resolution was unconstitutional. Once the Senate concluded its process, the Deputy President ceased to hold office, and nothing in the Constitution required a waiting period before gazettement. Likewise, the President cannot be faulted for acting swiftly under Article 149. He was constitutionally obligated to nominate a replacement within 14 days. Compliance with this duty cannot be construed as wrongdoing. To hold otherwise would penalize constitutional actors for fulfilling their obligations. The same reasoning applies to the National Assembly. Article 149 allows up to 60 days to vote on a nomination, but it does not require Parliament to exhaust that period. Acting sooner than the deadline is not evidence of illegality. Speed alone does not establish predetermination. The law requires objective proof that a decision maker had closed their minds before exercising power. Mere expedition does not meet that threshold. We therefore find that the gazettement of the Senate resolution, the President nomination of His Excellency Kindiki, and the National Assembly's approval did not contravene the Constitution simply because they were undertaken expeditiously. I will now turn to the constitutional processes. Under this heading, this court is called upon to interpret Articles 144 and 145 of the Constitution to determine whether the Senate was obligated to establish a special committee to investigate the charges against the Deputy President, or whether the formation of such a committee was discretionary. The court is equally invited to examine the procedures applied in the impeachment process, with particular focus on Article 150, sub-Article 2, and the extent to which, if at all, the Senate ran afoul the Constitution in that respect. Starting with the first issue, the dispute before us brings into sharp focus the jurisprudential tension embedded in Article 145 of the Constitution, and more particularly, Article 145, sub-Article 3b of the Constitution. Article 145, sub-Article 2 and sub-Article 3 detail the provision of removal in the following terms. I do not need to read those provisions, and I proceed. The true import of Clause 3b cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of historical continuum just a minute. Yes, I proceed. The true import of Clause 3b cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of the historical continuum of Kenya's constitutional reform. Constitutional interpretation, particularly in matters touching on the architecture of the governance, must be informed by history, for history illuminates the intent of the framers, constitutionalizes the text, and guards against distortion that arise from reading provisions in a vacuum. As the courts have consistently held, Constitution is not merely a legal instrument, but a living charter whose meaning is entrenched by the struggles, compromises, and aspirations that birthed it. Accordingly, this inquiry necessitates tracing the evolution of impeachment clause through the Bomas draft, the Wako draft, and the harmonized draft to appreciate the context of Article 145, Subarticle 3B was ultimately incorporated into the Constitution. Article 164 of the Bomas draft outlined the procedure for impeachment, vesting the Senate with ultimate authority. It provided that upon receipt of a resolution from the National Assembly, the Speaker of the Senate would convene the Senate, and if the motion was passed, a special committee of the 13-member will be appointed to investigate the matter. The language of the Bomas draft was rigid and prescriptive. The investigatory phrase was mandatory, and the committee route was the inescapable mechanism for digesting evidentiary complexities prior to a final vote. If the committee found the allegations unsubstantiated, no further proceedings would ensure. For avoidance of doubt, it provided as follows. The Speaker of the Senate shall, if Senate is then sitting or has been summoned to bring the motion to the notice of the Senate for the consideration within 7 days, or if Senate is not then sitting, will summon it to meet within 21 days of the motion, 21 days of the notice to consider the motion. If a motion is passed under Clause 3, the Senate shall appoint 13 of its members as a special committee in accordance with its standing orders of the Senate to investigate the matter. If the special committee shall investigate the matter and shall, within 10 days, report to the Senate whether it finds the particulars of the allegations against the President to have been substantiated. End of quote. Similarly, Article 155 of the Wako draft mandated the formation of a special committee of 13 members of Parliament to investigate allegations once an impeachment motion was initiated. The provision was explicit and inflexible, leaving Parliament with no discretion. The committee route was compulsory, and the President retained the right to appear and be represented before the committee. For clarity, we have reproduced that one as well, but I will not go through it. I proceed. The harmonized draft of 2009 and its subsequent revision in 2010 represents the constitutional settlement now embodied in Article 145, which is the subject of contestation before us. To our mind, there appears to have been a deliberate harmony in the manner the previous drafts treated the committee stage of the impeachment proceedings. We are convinced that the framers intended to preserve this consistency across the drafts rather than to depart from it. This conclusion is fortified by a wholesome reading of the Constitution, which we explain in detail. Interpreting the text before us requires a careful and nuanced exercise in constitutional interpretation. Fortunately, the Constitution itself provides guidance on how it should be read. Articles 20, Subarticle 4, and Articles 259, Subarticle 1 establish the interpretive framework. Article 20, Subarticle 4 directs courts when interpreting the Bill of Rights to promote the values of an open and democratic society founded on human dignity, equality, equity, and freedom, while giving effect to the spirit and the objects of the Bill of Rights. Article 259, Subarticle 1 further commands courts to interpret the Constitution in a manner that advances its purpose, values, and principles, threatens the rule of law, protects human rights and fundamental freedoms, permits development of the law, and contributes to good governance. Over time, our courts have consistently emphasize that the 2010 Constitution demands a transformative approach to interpretation. Recognizing its highly progressive nature, courts have articulated several interpretive canons. In David D. and others, as its AG, the High Court, that is the BBI case, the High Court identified 4 guiding principles: that the Constitution must be interpreted holistically, that it should not be approached with rigid formalities or treated as a mere statute, that its own theory of interpretation must be applied to safeguard its values, objects, and purpose, and that non-legal consideration are essential to uncover the true meaning and values. The Supreme Court, in the matter of Kenya National Commission on Human Rights 2014, clarified that a holistic interpretation requires contextual analysis, which means reading provisions alongside and against each other, informed by history, disputes, and prevailing circumstances. Similarly, in the Tunyefuza versus AG case, this is a Ugandan court, stressed that a constitution must be read as an integrated whole with each provision sustaining rather than undermining the others. The principle that the Constitution must not be interpreted through rigid formalism was also emphasized by the Supreme Court in Interim Independent Electoral Commission 2011 and the Communication Commission of Kenya versus Royal Media Services 2015. The court observed that constitutional interpretation requires more than positivistic approaches. The court noted that Articles 20, Sub-Article 4, and Articles 259, Sub-Article 1 incorporate non-legal considerations such as historical, social, cultural, and political realities that must inform judicial reasoning. The court highlighted that Kenya's modern Bill of Rights envisages a human-based approach and social justice-oriented society, and judicial authority derived from the people under Article 159, Sub-Article 1 must reflect these values in court decisions. The former Chief Justice Emeritus Mutunga, in his concurring opinion in the Speaker of the Senate and another versus the AG, this is 2013 reported, also underscored the constitution making was an ongoing process, and acknowledged that compromises in drafting often create vagueness, and it is the court's responsibility to resolve contradictions and clarify gaps. In his words, I quote, "Constitution making does not end with the promulgation. It continues with the interpretation." Finally, the Court of Appeal in Center for Rights, Education and Awareness, and another versus John Harun Mwau, 2012 reported, linked constitutional interpretation with the statutory interpretation principles. It reiterated that courts must avoid absurd, unpracticable, illogical, and artificial results, and must always strive to serve the public interest. Fidelity to both the letter and the spirit of the Constitution requires interpretations that advance justice, rationality, and the common good. Guided by the interpretive principles discussed above, we now turn to examine the purpose and the intent of Article 145, Sub-Article 3 of the Constitution. We do so with full appreciation of the demands of judicial humility and the doctrine of stare decisis, which binds inferior courts to the pronouncements of superior ones and is the bedrock of coherent and predictable legal order. Our analysis is therefore offered within that framework, not as a departure from it. We are aware that the Supreme Court has determined the question in the Sonko decision, and we are mindful that the suggestion we are advancing in this discussion will build upon the existing jurisprudence and contribute to the broader legal discourse on this question. It is in that spirit and with deference owed to the Supreme Court that we nonetheless set out the following reasoning. Having already traced the historical development of this provision, a comparison of the earlier drafts with the current text reveals a consistent approach to the introduction of a removal motion from the National Assembly. In every instance, the motion was to be formally tabled for consideration. The draft made clear that once introduced, the motion will be debated, and if passed, the special committee constituted. This framework is now embedded in Article 145(3)(a) of the 2010 Constitution, which expressly obligates the Senate to convene and or hear the charges against the President. These charges are the charges as contained in the removal motion transmitted from the National Assembly pursuant to Article 145, Subarticle 2. It is only after the Senate has heard the charges that Article 145, Subarticle 3b comes into play. It is important to note that the motion was never intended to be passed or dismissed as a mere formality. The House was called upon to consider, debate, and to resolve whether the motion should proceed or fail. If the motion failed, that marks the end of the matter, and no further proceedings will follow. Conversely, if Parliament determined that the matter warranted investigation, it passed a resolution allowing the impeachment motion to proceed, and a special committee is then formed. Returning to Article 145, Subarticle 3A, upon receipt of the removal motion, the Senate is required to hear the charges. While this hearing may not necessarily connote a formal trial, it provides an opportunity for the House to be appraised of the charges, the supporting evidence, and any accompanying documentation. At this stage, the Senate must decide by resolution whether the charges merit investigation. It is also at this point that the House considers whether the other preliminary requirements, such as the constitutional threshold, were properly satisfied by the National Assembly in the first place. We have examined the Hansard record of the Senate sitting on Wednesday, the 9th of October 2024, convened pursuant to Kenya Gazette Notice number 13170. The record shows that the Honorable Speaker of the Senate duly appointed the session for the purpose of hearing the charges against the then Deputy President. During the sitting, the Speaker read out all 11 charges and formally laid before the Senate the documents conveying the resolution of the National Assembly. These materials included the notice of special motion, affidavit of Honorable Ekoman Mwengi Mutuse, MP, electronic evidence relating to the motion, order papers, communications from the chair, certified Hansard record, votes and proceedings, public participation notices, correspondences from the advocates, press statements, court orders, and other supporting documentation. The Honorable Speaker proceeded to draw the attention of the House to the special and the unique nature of the business before it. It reminded senators that impeachment is a fundamental tool of legislative oversight and a critical component of the constitutional framework of checks and balances, noting further that the matter had attracted immense public interest. The Speaker then outlined the way forward, informing the House that by its resolution, it had two options of handling the motion, either through a special committee or in plenary. Significantly, the procedure adopted by the Speaker reveals that once the charges and supporting evidence were laid before the House, there was no opportunity for senators to deliberate on whether further investigations were necessary. In particular, the House was not afforded the chance to engage in a substantive inquiry into the propriety of the process undertaken by the National Assembly or the validity of the charges themselves. The question that now arises is whether, it was necessary for the Senate, in the first instance, to address itself to the need for investigations before proceeding to the actual hearing of the motion. It must be emphasized that the Senate is not a mere conveyor belt for the matters originating from the National Assembly or any other entity. Rather, it is a revered house vested with autonomy and empowered to make decisions by way of resolution. The Senate, therefore, retains discretion to determine whether to accept any motion, petition, or request for further deliberation, save in circumstances where the Constitution or statute expressly removes such discretion. This explains why the earlier drafts of the Constitution stipulated that a motion had to be passed before a special committee could be formed. The design was deliberate. The House was first required to decide whether the motion should pass or fail, and only upon passage will the question of constituting a special committee arise. A useful instruction of this principle is found in the legislative process. Not all legislation automatically passes to the Senate. Article 114, for example, requires the Senate to consider whether a bill transmitted from the National Assembly falls within its jurisdiction and warrants deliberation in the House. Article 145, subarticle 3b, is therefore not unique in this regard. It was intended to give the Senate an opportunity to hear the charges, examine the evidence, and satisfy itself that at least the bare minimum constitutional and statutory requirements had been met on a prima facie basis. In doing so, the Senate would address fundamental preliminary issues, such as whether the grounds of the special motion fall within those provided for in the Constitution or law, whether the jurisdiction had been properly invoked, whether the president was previously tried on the same charges, whether prima facie evidence supports the charges, and whether the requisite threshold was attained in the National Assembly. It is only after the Senate has addressed these preliminary issues that it proceeds to take a vote by way of a resolution on whether to admit the motion for a full hearing or to defeat it. This explains the deliberate use of the word may in Article 145, subarticle 3b. The term may signifies discretion on the part of the Senate to determine whether the motion, as presented, satisfies the minimum constitutional and statutory requirements and therefore warrants further consideration. Once such a resolution is made and the Senate decides to proceed, the House then turns to the procedure governing the hearing. Conversely, if the Senate is not satisfied that the motion merits further interrogation, the matter ends there. There is therefore no ambiguity in the use of the word may in Article 145 3b. It clearly connotes discretion and cannot be equated with the mandatory term shall. The true meaning and intent of Article 143b can only be appreciated in light of that historical context. To interpret the provision in isolation would risk stripping the Senate its discretion to determine what matters it can lawfully consider. This position finds support in the commentary of legal scholars, Louis Franceschi and Piero Lumumba, in the book Constitution of Kenya, a documentary, 2nd edition 2019, where they stated as follows, and I quote, "In order to avoid abuse of Parliament's power to impeach a president, the Constitution appropriately provides for 2/3 majority threshold of the total number in both houses of Parliament. Furthermore, the Senate is called to constitute a special committee to investigate the charges against the president and present a report as opposed to just voting at the National Assembly. In order to ensure fairness of the Senate's committee proceedings, the president has the right to appear and be represented before the special committee during its investigation," end of quote. Upon careful perusal of the Senate Hansard, however, we did not find any debate or proceedings or resolution indicating that the House interrogated the motion as presented from National Assembly or resolved on the way forward. The record shows that once the motion was laid before the House, the charges were read out and the supporting evidence tendered. That was all. No resolution admitting the motion to a full hearing was made. The Senate instead proceeded to address directly to address itself on the issue of the charges to be had. In our view, going by our rendition, we will not have approved this way forward. Having so established, we take the position that once Senate resolves to admit and proceed with the hearing of the motion, its discretion is spent. The only cause available is to appoint the special committee to investigate the matter. This conclusion flows naturally from the foregoing discussion and from the deliberate manner in which sub-articles 145, sub-article 4, 5, and 7 are structured. These provisions build upon the process once the special committee is constituted, setting out the subsequent stages of investigation and the right of the Deputy President to appear and be represented before the committee, the tabling of the committee's report before the plenary, a second opportunity to the Deputy President to be heard, and finally, the Senate's vote. We ask ourselves, if the intention had been to follow a direct plenary route, why would the drafters not have said so? Why would they have crafted such a detailed provision for the committee process, only to mention the Senate at the tail end of that process? The deliberate sequencing of sub-articles 145, 4, 5, 6, and 7 leaves no doubt in our minds that the committee mechanism was intended to be the exclusive path once the Senate resolved to proceed. The plenary option was never envisaged as a substitute for the committee process, but rather as the forum for receiving and debating the committee report. To hold otherwise, according to us, will create an absurdity in which the Senate as a house would investigate and then present to itself the investigative report for voting. At the risk of repetition, but for emphasis, we observe that the removal of the president by way of impeachment was not provided for in the retired 1963 Constitution, save for this superficial vote of no confidence. Kenyans were therefore deliberate in crafting a detailed procedure for the hearing of an impeachment motion under the 2010 Constitution. This procedure is well captured in the sub-articles to Article 145, which specify the number of members to be appointed to the special committee, the committee's role in investigating the charges, and the strict timeline of 10 days within which the committee must act. Sub-article 145.5 further commands the observance of the two distinct rights of the president. First, the right to appear before the committee personally, and second, the right to be represented. These rights are not synonymous. The right to appear is exercised by the president as an individual, whereas the right to be represented allows the president to appear alongside counsel or to have counsel appear on his or her behalf. These two rights must be juxtaposed with the right provided for in sub-article 145.6b, which grants the president an opportunity to be heard at the plenary once the committee finds any of the charges substantiated. This right is again distinct, as an opportunity to be heard is not limited to physical or oral hearing, but encompasses the broader ability to present a defense in whatever form the Senate deems appropriate. This interpretation ensures a generous reading of the rights of the president, who is afforded representation and opportunity to be heard both at the committee stage and again before the plenary. Such a generous interpretation is precisely what the Constitution commands. For all the foregoing reasons, we do find that Having expressed our view, we again defer unreservedly and with the deepest respect to the binding authority of the Supreme Court as settled in Soko versus County Assembly of Nairobi, where the court pronounced itself as follows. I quote, "In the previous ground, 2 above, we categorized the process of removing a governor into 2 stages. This is the second stage. From subsection 3 of Section 33 of the County Government Act, the process moves to the Senate from the County Assembly. Within 7 days after receiving notice of a resolution from the Speaker of the County Assembly confirming the passage of the impeachment motion, the Speaker of the Senate must convene the meeting of the Senate to hear the charge against the governor. The charges can be heard in the Senate plenary or in a forum of a special committee of the Senate that reports to the full Senate. In either case, the governor is entitled to attend and to be represented by counsel during the investigations. It is only when sufficient evidence is presented to substantiate the claims that the Senate will according the governor an opportunity to be heard, vote on each of the charges. If a majority of all the members of the Senate vote to uphold any of the charges, then the governor shall cease to hold office. We reiterate that proof of even a single charge will be sufficient for purposes of Article 181 of the Constitution. But should the vote for removal fail, that brings the proceedings to an end. End of quote. That pronouncement represents that settled and binding position of law. We are constitutionally obliged to follow it, and we do so without reservation, notwithstanding the views which we express above. We observe in passing that although the Supreme Court pronouncement in Sonko was referred in the context of interpreting the County Government Act, the provisions of the Act mirror the virtual identical terms, the language of the Article 145 of the Constitution. That correspondence reinforces its application to the present matter.
We now move to the final issue that we considered, and that is the issue of a fair trial. The gist of this issue turns on whether His Excellency Gachagua was subjected to a lawful and fair trial process within the meaning of Articles 47 and 50 of the Constitution. The petitioners contended that the Senate's conduct of the impeachment trial was fundamentally and irreparably flawed, falling far short of the constitutional standards of fairness, legality, and procedural propriety granted to His Excellency Gachagua under the stated provisions. Their challenge on this ground was advanced on several distinct and cumulative bases. They argued that His Excellency Gachagua was denied his right to a fair trial when, having fallen ill and being hospitalized on the 17th of October 2024, the Senate refused adjournment request and proceeded in his absence, ultimately voting on 5 of the impeachment charges. That the Senate was constitutionally bound under Article 145(3)(b) and 145(4)(6) to appoint a special committee of 11 members to investigate the charges. By defeating the motion to establish such a committee and proceeding by plenary, the Senate deprived him of his right under Article 145(5) to appear and be represented before an independent investigative body. insulated from political pressure, and that the time afforded to H.E. Gachagua was grossly inadequate, only a few days to respond to 11 complex allegations and just 2 hours to present his defense compared to the extensive time given to the National Assembly. The respondents in defense maintained that the Senate had accorded His Excellency Gachagua a lawful and fair trial consistent with Articles 47 and 50 of the Constitution, that the Senate acted reasonably by granting a short adjournment and offering a further extension to 19th October 2024, and when the formal motion was defeated, they submitted that discretion had been properly exercised, especially since no medical evidence was produced. They maintained that the Constitution conferred discretion to proceed by way of a special committee or plenary under Article 145(3)(b, and denied that new evidence or witnesses were introduced at the Senate stage as alleged by H.E. Gachagua. We have carefully considered the forcefully and ably argued positions advanced by both sides. The constitutional standard which the fairness of the Senate conduct falls to be measured is clearly and comprehensively set out in Article 50 of the Constitution. Of particular relevance to the present inquiry are the following guarantees which Article 50 confers on every accused person as components of the right to a fair trial. Under 50C is the right to have adequate time and facilities to prepare a defense. F, to be present when being tried, unless the conduct of the accused person makes it impossible for the trial to proceed. And K, to adduce and challenge evidence. These guarantees do not stand alone. They are reinforced and complemented in the specific context of impeachment proceedings by the procedural rights expressly conferred by Article 145(5) and 145(6)(b of the Constitution, which provide as follows. 5. The President shall have the right to appear and be represented before the special committee during its investigations. And in 6B, that Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. To the foregoing must be added Article 47 of the Constitution, which guarantees every person the right to fair administrative action that is lawful, reasonable, and procedurally fair. That right is not confined to purely judicial proceedings. It attaches to any exercise of public power that affects a person's rights, interests, or legitimate expectations, and it applies with full force to the impeachment process before a decision to remove is taken. The Supreme Court in Sonko reaffirmed this position, holding that during the process of removal, both the right to fair administrative action under Article 47 and the right to a fair hearing under Article 50 accrue to the office holder whose removal is sought. This court reads that holding as applying with equal force to His Excellency Gachagua in the present proceedings. The Supreme Court further held that while impeachment is a political process, it is equally subject to constitutional discipline and the principles of natural justice, and that courts will not interfere with the merits of Parliament's decision unless a violation of fair hearing rights or procedural improprieties established. These two propositions together define both the standard the Senate was required to meet and the scope of this court's supervisory jurisdiction in assessing whether it did so. Against that framework, we turn to the specific circumstances of the present case. It is clear that during the proceedings, the National Assembly, as the prosecuting party in the Senate proceedings, presented its case through witnesses who were examined in chief and subjected to cross-examination in the full and formal sense of adversarial proceedings. There is no controversy about this fact. The petitioners contend that the Senate's refusal of the adjournment application denied His Excellency Gachagua equality of arms and equal protection of the law by preventing him from participating in the oral proceedings at the precise stage when his own evidence was to be led. The constitutional right to equality of arms has been expressly affirmed by the Court of Appeal in Olo versus Kisumu County Assembly Service Board and another, when the court cited with approval the following passage from Pinnacle Project Limited versus Presbyterian Church of East Africa, Gong Parish, and another. I quote, "Fair trial in civil cases includes the right of access to a court, the right to be heard by a competent, independent, and impartial tribunal, the right to equality of arms, the right to adduce and challenge evidence, the right to legal representation, the right to be informed of the claim in advance before the suit is led, the right to a public hearing, and the right to be heard within a reasonable time." The question in the present case is not whether H.E. Gachagua was given any opportunity to be heard. From the evidence before us, he was. The precise and constitutionally significant question is whether, having been partially heard, the remainder of his participation was unlawfully curtailed at the point when the opposing party had already completed a full adversarial presentation. The National Assembly had presented its case in its entirety, its witnesses had testified, been examined, and cross-examined. His Excellency Gachagua had not completed his. It was at that precise point of procedural imbalance, with the scales of participation tilted irrevocably in favor of one party, that the Senate refused the adjournment and proceeded to vote. That is not a case of a party who was heard and then outvoted. It is a case of a party who was prevented from completing his hearing after his opponent had completed his. What we heard the petitioners to be saying is that His Excellency Gachagua critically was not merely a respondent who had filed documentary evidence. He was, on the uncontroverted evidence before this court, his own sole witness. He was the only person who could speak to the facts from his own personal knowledge, give a first-hand account of the allegations before him, and submit himself to cross-examination in a manner that would have allowed the Senate to assess his credibility directly. The respondents relied on the Court of Appeal's decision in Kenya Revenue Authority versus Murgani, a 2010 decision, for the proposition that fairness does not always require an oral hearing, and that provided a body achieves the degree of fairness appropriate to its task, the manner in which it proceeds was a matter for its own institutional judgment. Drawing on local government vote versus Aldrich, as well as the case of Selvarajan versus Res Relations Board and R versus Immigration Appeal Tribunal, the Court of Appeal in the Murgani case concluded that a hearing conducted by way of written exchange may, in appropriate circumstances, constitute a fair hearing. We do accept that general principle as binding on us. However, Murgani is plainly distinguishable on the facts and context that are both material and decisive. That case concerned an administrative determination in which no oral proceedings had been conducted at all. Both parties were in a position of formal procedural equality. The written process was the established mechanism, and the question was simply whether the absence of an oral hearing was fatal to fairness. The present case is fundamentally different. The Senate did not choose at the outset to proceed by way of written submissions alone. It had agreed to a fully adversarial oral hearing with witnesses, examination in chief, and cross-examination. Having adopted that mode of proceeding, the Senate could not, at the moment His Excellency Gachagua was to take the stand as his own sole witness, abandon the adversarial framework it had established for itself without satisfactory reason. To do so was to apply different procedural standards to the two parties. That disparity is the antithesis of equality of arms and is irreconcilable with the constitutional guarantees of Article 47 and Article 50. The Hansard record of the Senate proceedings of 17 October 2024 confirms that following the confirmation by Paul Mwita Senior Counsel to the House that His Excellency Gachagua had been taken ill, several senators who rose to comment explicitly acknowledged on the floor of the Senate that H.E. Gachagua was unwell. Not one of these senators disputed the illness. They acknowledged it and then proceeded, notwithstanding that acknowledgement, to oppose the adjournment application. The circumstances must also be taken within the directions issued by the Speaker of Senate at the time. The Honorable Speaker stated in part as follows, I quote, "As this process is time-bound by the Constitution to be concluded in not more than 10 days pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday the 19th of October 2024, the only window open to the Senate, if it is so obliged, the request for adjournment sought by counsel for the Deputy President would be to gazette Saturday the 19th of October 2024 as a further and final day for hearing of this matter. Honorable Senators, ladies and gentlemen, such a request is not made to the Speaker but to the Senate and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter. This being the last day allowed by the Constitution of Kenya for these proceedings to conclude. I close the quote. The Speaker's communication meant that it was in fact open to Senate to adjourn the sitting up to Saturday. The significance of that course of conduct cannot be overstated. The Senate, despite having the option to adjourn and having expressly acknowledged the incapacity of the party before it, nonetheless proceeded to determine his fate in his absence. That was not a proper exercise of constitutional discretion. It was a negation. We are convinced that had the Senate exercised its discretion genuinely, open-mindedly, and with a conscientious regard for the constitutional rights of His Excellency Gachagua, and had it directed its mind to the miscarriage of justice that its refusal was plainly going to occasion, this was a case in which the circumstances unambiguously called for an adjournment to be granted at least to the next day. That conclusion is firmly supported by the Court of Appeals pronouncement in Kariuki versus Attorney General, a 2014 decision, where the court held as follows, again I quote, while bearing in mind that whether to grant an adjournment or not is discretionary, and appellate courts are loath to readily question the exercise of discretion by the trial court, nevertheless, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of applications for adjournment of criminal trials, nevertheless, because of the constitutional basis of that right and the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. In denying the appellant's application for adjournment, the court-martial in that particular case also did not address its mind to the critical question of whether denial of the adjournment would occasion a miscarriage of justice. In Job Obanda versus Stage Court International Services Limited and another, this court, that is the Court of Appeal, was emphatic that where, amongst others, a judge fails to apply his mind to the question whether a miscarriage of justice might be occasioned to a party who is refused an adjournment, that would constitute sufficient basis upon which an appellate court would be entitled to interfere with the exercise of jurisdiction, close of quote. We say so with a full appreciation of the non-derogable nature of the right to a fair trial. It is not a right that yields to constitutional timelines or political exigencies. It is an absolute constitutional guarantee, and its violation cannot be justified by reference to any competing constitutional interest, however weighty or pressing that interest may be. This finding becomes even more compelling when one considers the Senate's misdirection in its interpretation of Article 145(4)(b). Senate appeared to imagine that it had 10 days within which to dispense the impeachment hearing itself. Yet, the text and structure of that provision, according to us, make it clear that the 10-day period was intended to apply exclusively to the special committee once constituted. We have addressed in detail our understanding of Articles 145(3)(b) and 145, sub-article 4 to 6 in the preceding section of this judgment, and we do not propose to repeat that analysis again here. Finally, we wish to make brief observations on the affidavit of Dr. Daniel Kibuka Gikonyo, sworn on the 28th of April 2026, which was admitted into evidence by leave of this court and tested by cross-examination when Dr. Gikonyo attended to give oral testimony. There is no doubt that the affidavit was not before the Senate on the 17th of October 2024 when the request for adjournment was made. And on that ground, we do agree with Senate's submission that it could not have informed the House's determination at the time. The affidavit was additionally filed almost 2 years after the petitions were instituted, and no explanation was offered to us, including by Dr. Gikonyo himself, for that delay. For those reasons, we do not attribute significant probative value to it. The circumstances, as we have analyzed, were independently and collectively sufficient to warrant a reasonable adjournment. Dr. Gikonyo's evidence neither adds nor detracts from that conclusion.
In conclusion, therefore, upon careful consideration of the consolidated petitions, The responses filed, the submissions of counsel, and following our deliberations and analysis, we now pronounce ourselves on the issues presented. On jurisdiction, we hold that the impeachment proceedings challenged herein are justiciable. This court possesses jurisdiction under Articles 22, 23, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. On allegations of bias, the allegations of bias, predetermination, and conflict of interest advanced against the speakers, members of parliament, and senators are unsubstantiated. They rest on political inference and suspicion rather than objective evidence capable of satisfying the required threshold. On public participation, we are satisfied that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua met the constitutional threshold. The Senate did not violate Articles 10 or 118 by failure to conduct its own independent public participation. We further hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149, Sub-Article 1. Constitutionality and legality of standing orders. We find and hold that the impugned standing orders of the Senate and the National Assembly are not unconstitutional. Composition of the National Assembly, role of IEBC, and nomination of the Deputy President. We find that while the failure by Parliament to enact legislation on the gender rule remains a constitutional concern, this court has recently clarified in the Conchella and others decision that the remedy under Article 261 is still available and must be pursued through the proper procedural channels. Consequently, it would be premature to hold that the National Assembly was improperly constituted for purposes of considering the impeachment motion. We find that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149, Sub-Article 1. The absence of IEBC involvement did therefore not render the nomination or filling of the vacancy unconstitutional. The gazettement of the Senate resolution, the President's nomination of His Excellency Kindiki, and the National Assembly's approval did not contravene the Constitution merely because they were undertaken expeditiously. We therefore affirm that the nomination and appointment of His Excellency Kindiki as Deputy President was valid. Constitutional processes. We find that Parliament ought to urgently enact a dedicated statutory framework for the removal of the Deputy President under Article 150. The phrase, in quote, with the necessary modifications, is a substantive constitutional directive requiring Parliament to adapt the presidential removal framework to the distinct constitutional position of the Deputy President. However, the absence of such legislation does not vitiate the impeachment process already undertaken. We further hold that under Article 145, the Senate was at liberty to conduct the trial either by way of plenary or through special committee. The right to fair trial under Article 47 and Article 50, we find that His Excellency Gachagua's rights were infringed when the Senate declined to allow an adjournment. This violation constitutes both a vindication of his rights and a recognition of the constitutional infirmity in the process, but does not undo the impeachment itself, given the finality of Article 145, Sub-Article 7, and the constitutional absurdity that would arise from dual incumbency. The Constitution is the grundnorm, and where that grundnorm deliberately and unequivocally withholds authority from the court, such limitation must be respected.
I will deal with the aspect of remedies. Before pronouncing our final orders, we deem it necessary to first address the nature of remedies sought and to explain their constitutional foundation. This court has been invited to grant various reliefs arising from the partial success of the consolidated petitions. Our jurisdiction to issue such reliefs is firmly anchored in Article 23 of the Constitution, which empowers the court to grant appropriate remedies for the enforcement of rights and fundamental freedoms. These remedies include declarations of rights, injunctions, conservatory orders, declaration of invalidity of any law that denies, violates, infringes, or threatens a right or fundamental freedom in the Bill of Rights and is not justified under Article 2, Subarticle 4, orders of compensation and orders of judicial review. The courts have over time provided guidance on the considerations applicable in granting constitutional reliefs. In affirming that a court is not confined to the remedies expressly enumerated under Article 23, the Court of Appeal in Total Kenya Limited versus Kenya Revenue Authority 2013 reported, held that even where specific reliefs are expressly provided, a court is not precluded from issuing any other orders under the inherent jurisdiction, as long as such orders are necessary to ensure that justice is done between the parties. In the same vein, the High Court in Simeon, Kioko, Kitheka, and 18 others was the county government of Machakos and others, held that Article 23 of the Constitution does not expressly bar the court from granting conservatory orders where the constitutionality of legislation is challenged. Similarly, in Republic versus Ex parte, Chudasama, the court emphasized that courts retains inherent jurisdiction to fashion appropriate remedies to secure the ends of justice. Speaking to the nature of appropriate reliefs, the Constitutional Court of South Africa in Force versus Minister of Safety and Security said as follows, and I quote, appropriate relief will in essence be relief that is required to protect and enforce the Constitution. Depending on the circumstances of each particular case, the relief may be a declaration of rights, an interdiction, an interdict, a mandamus, or such other relief as may be required to ensure that the rights enshrined in the Constitution are protected and enforced. If it is necessary to do so, the courts may even have to fashion new remedies to secure the protection and enforcement of these all-important rights, end of quote. Regarding declarations and damages for constitutional violations, the Court of Appeal in Gitobo, Imanyara, and others versus Attorney General, report in 2016, emphasized that constitutional remedies are not confined to declarations alone, but may extend to compensatory relief where rights have been infringed. The court observed that damages serve not merely as recompense to injured party, but also as a means of vindicating the Constitution itself, and ensures that violations are met with effective and meaningful redress. In referring to Lord Nichols at paragraph 18 and 19 of that decision, the Court of Appeal affirmed the position that, and I quote, when exercising this constitutional jurisdiction, the court is concerned to uphold and vindicate the constitutional right which has been contravened. A declaration by the court will articulate the fact of the violation, but in many cases, more will be required than words. If the person wronged has suffered damage, the court may award compensation. The comparable common law measures of damages will often be a useful guide in assessing the amount of this compensation. But this measure is no more than a guide, because the award of compensation under Section 14 is discretionary, and moreover, the violation of the constitutional right will not always be conterminous with the cause of action at law. An award of compensation will go some distance towards vindicating the infringed constitutional right. However, how far it goes will depend on the circumstances, but in principle, it will not suffice. It may not suffice. In fact, that the right is violated was a constitutional right adds an extra dimension to the wrong. An additional award, not necessarily of substantial size, may be needed to reflect the sense of public outrage, emphasize the public outrage, emphasize the importance of the constitutional right and the gravity of the breach, and to deter further breaches. End of quote. All these elements have a space in this additional in the additional award. Redress in section 14. Sorry, that's still the quotation, which I did not go through it. In this present case, and against this background, and having found that the rights of His Excellency Gachagua, were infringed, it is our considered position that declaratory relief and reasonable damages ought to be granted, not only to address the injuries suffered, but also to vindicate the Constitution and deter future violations. We now turn to examine the efficacy of the other reliefs. The petitioner sought an extensive range of remedies. In total, 49 declarations were prayed for, distributed across several thematic areas. 9 declarations relating to public participation, 15 declarations touching on the impeachment motion and process, 3 declarations on the fair hearing and due process, 3 declarations concerning the Senate proceedings and committee process, 2 declarations on standing orders, 1 declaration on the National Assembly and the gender representation, 8 declarations on the appointment of His Excellency Kindiki as Deputy President, 5 declarations on the vacancy in the office of the Deputy President and the nomination process, 2 declarations on violation of voters' rights, and 1 declaration regarding the members of the NIS. Beyond declaratory relief, the petitioner has also sought 5 orders in the nature of certiorari, 2 orders of mandamus, and 2 injunctive orders. They further prayed for reinstatement of His Excellency Gachagua to the office of Deputy President, an order for apology and cause. In addition, there was an elaborate prayer for damages and compensation. In considering the relief sought, it is evident that the 2 prayers have become moot. The first is the injunction that seeks to restrain the President, National Assembly, and any other state organ from proceeding with or effecting the appointment of any person to the office of the Deputy President pending the hearing and determination of the petitions. The second is the conservatory order restraining the respondents from collecting signatures, lodging any motion, or conducting any proceedings seeking to impeach the Deputy President. For clarity, these prayers are disallowed. Regarding the relief seeking the reinstatement of His Excellency Gachagua as the Deputy President of the Republic of Kenya, we do note that His Excellency Gachagua, through his pleadings and submission by his legal team, expressly abandoned the quest for reinstatement and indicated that he was no longer interested in pursuing it. Nevertheless, since other petitioners continue to press for the said relief, it remains necessary for this court to pronounce itself on the matter. Article 145, subarticle 7 of the Constitution provides as follows: I quote, "If at least 2/3 of all the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office." This provision speaks to the finality of the Senate's resolution once it upholds an impeachment charge. Upon such resolution, the President or Deputy, as the case may be, stands impeached and ceases to hold office. The constitutional text is categorical that the cessation of office is automatic and does not require any further act of implementation. The impeachment resolution, once validly passed by the Senate, is self-executing and a fait accompli. The constitutional design is deliberate in this respect. It does not envisage an instance where the impeached president or deputy president may be reinstated within the framework of the presidency. The vacancy resulting from the impeachment resolution can only be filled through the procedure under Article 149, Sub-Article 1. Even in the unlikely event that Parliament and the President wish to return the impeached office bearer, such a cause will still be subject to the availability of the vacancy and the nomination process prescribed by the Constitution. To hold otherwise presents profound constitutional and practical difficulties. The office of the Deputy President is not merely a matter of judicial declaration, but is intertwined with constitutional processes, political accountability, and the functioning of the executive. To order a statement in circumstances where the vacancy has already been filled would amount to the court usurping powers reserved to the people and their representatives under the Constitution. It would upset the delicate balance of separation of powers and create a constitutional absurdity. For the Constitution does not envisage two serving deputy presidents at any one time. The court cannot undo what the Constitution itself declares to be conclusive. Reinstatement, therefore, is not a viable or appropriate relief in the circumstances of this matter. Before leaving this subject, we find it necessary to acknowledge and comment on the doctrine of constitutional dilemma that arises in these proceedings from the tension between the constitutional finality of impeachment and the vindication of rights. This tension is highlighted by the comparative jurisprudence, most notably in the United States, where courts have adopted a principle of total avoidance, treating impeachment as non-justiciable. Yet our own constitutional framework demonstrates that avoidance cannot resolve the question that persists. In view of the recurring tension, a constitutional amendment clarifying the scope of impeachment finality and the role of judicial review may be warranted. At this juncture, we also find it necessary to distinguish the process of removal of a county governor from that of the president and the deputy president. To begin with, Article 181 of the Constitution sets out the grounds upon which the county governor may be removed from office. They are gross violation of the Constitution or any other law, B, serious reasons to believe that the governor has committed a crime under national or international law, C, abuse of office or gross misconduct, and D, physical or mental incapacity to perform the functions of the office. Article 181, Sub-Article 2, assigns Parliament the responsibility of enacting legislation to provide for the procedure for removal of a county governor. That legislation is the County Government Act, which we'll be referring to as the County Act in this discussion. And Section 33 thereof prescribes the detailed procedure. It provides for initiation of a motion in the County Assembly, transmission of the resolution to the Senate, investigation by a special committee, the governor's rights to be heard, and ultimately a vote by the Senate delegations. If upheld, the governor ceases to hold office. If rejected, the motion may only be reintroduced after 3 months. When this process is juxtaposed with the removal of a president and deputy president, and Article 144 and 145, several key differences emerge. First, whereas the president and the deputy president may be removed either on grounds of incapacity or impeachment, a county governor is removable only on the 4 grounds enumerated in Article 181. Section 33 of the County Act, however, introduces impeachment terminology, thereby expanding the constitutional parameters in a manner that is troubling. Second, the removal of the president and the deputy president is provided for directly in the Constitution, while the removal of a governor is legislated under the County Act. This distinction is critical. Under Article 2, Sub-Article 4, legislation is subordinate to the Constitution and may be declared unconstitutional by a court, whereas constitutional provisions themselves cannot be impugned. Thus, while the Senate vote under Articles 144 Sub-Article 10 and 145 Sub-Article 7 is final and beyond judicial review, the Senate vote under Section 33 Subsection 7 of the County Act is susceptible to challenge. Courts may proceed to stay and quash a resolution to remove a governor and even halt the filling in of the vacancy, but such judicial interventions cannot be imagined in the case of a president or the deputy president. Third, the manner of filling in the vacancies also differs. Under Article 149, a vacancy in the office of the deputy president is filled by presidential nomination and voting in the National Assembly, whose vote stands final and it is self-executing. By contrast, the Constitution does not prescribe how a vacancy in the office of deputy governor is filled. Section 32D of the County Act provides for nomination by the governor, approval by the county assembly, and appointment thereafter. This statutory process, unlike the constitutional one, is amenable to judicial review and may be stayed or quashed. It is therefore on account of these glaring differences that this court cannot apply mutatis mutandis, the jurisprudence on removal of county governors to the removal of the president or deputy president. We nonetheless affirm that where binding judicial findings on governors' removal are squarely applicable to issues before us, we cannot run away from the same. This includes the pronouncement by the Supreme Court on the second case on the choice between plenary or special committee. In sum, therefore, whereas Article 144 and 145 embodies what may be termed as constitutional finality, the provisions of the County Act represent a form of statutory finality, thereby actuating the distinction between the two. We now turn to His Excellency Gachagua's quest for pension and emoluments under Retirement Benefits Act. The preamble of the Act makes clear that it is an act of Parliament to provide for granting of pension and other emoluments, retirement benefits to persons who hold the office of Deputy President and persons who have served as Prime Minister, Vice President, Speaker, Deputy Chief Justice, or Chief Justice after 1st of January 1993 and for connected purposes. Section 7 of the Act provides for the pension and other benefits of a retired Deputy President or a retired Vice President. Section 2 defines a retired President as a person who, having held the office of Deputy President, has ceased to hold office as such in the manner specified in the Constitution. The interpretive question that arises is whether a Deputy President who ceases to hold office by reason of impeachment can be deemed a retired Deputy President within the meaning of the Act. Whether courts can legitimately interpret impeachment as retirement is a weighty and novel question. None of the parties address us on this issue. We are therefore of the considered position that it is not properly before us to pronounce ourselves on the same, for that will be presumptuous and will amount to stepping beyond the pleadings and the submissions of the parties. Accordingly, we decline to make any findings on this point. The parties are at liberty to pursue the matter further. An order of mandamus was sought to compel the National Assembly and the Senate to promulgate a constitutionally compliant procedure for removal of the Deputy President by impeachment. We find this prayer to be merited for clarity, the lack of such legislation per se does not, however, impugn the instant impeachment proceedings. Next, having found that the fair trial rights of His Excellency Gachagua were infringed when the Senate declined to allow the adjournment, that is a vindication of His Excellency Gachagua. We, however, hasten to add that the violation does not have the effect of quashing the Senate's resolution to impeach His Excellency Gachagua for precisely the same reasons we have provided with respect to the finality of the impeachment process. If the Senate's resolution were to be quashed or set aside, then by operation of law, the status quo ante will be restored, thereby effectively creating a scenario where there will be two deputy presidents in office at the same time. The impeached deputy president, reinstated by judicial fiat, and the successor duly appointed under Article 149, Article 1. We have no doubt that Kenyans did not intend such scenario, and the Constitution does not contemplate dual incumbency in the president. Accordingly, the infringement of fair trial indicated, it does not undo the impeachment. Remedy lies in declaratory in indicate the Constitution, not in quashing the Senate's resolution. In light of the foregoing, that is not to say that His Excellency Gachagua has no constitutional remedies given the violation of his rights. As we said, we are convinced that this is a case where the infractions on the part of His Excellency's right can be adequately vindicated by way of appropriate declarations and damages. Applying Gitobu Imanyara's case, it is our position that the violation of His Excellency Gachagua's fair trial rights during the impeachment proceedings calls for a remedy that goes beyond mere acknowledgement. Declaratory relief serves to formally recognize the infringement, while damages will provide redress and underscore the seriousness of the violation. This amount is not intended to compensate for the loss of office, but rather to vindicate the Constitution, restore the dignity of the affected party, and deter similar infractions in future impeachment proceedings. Lastly, we find that since most of the prayers sought in the consolidated petitions have failed, coupled with the public interest nature of this matter, parties herein ought to bear their respective course. Given that the Gitobu case was resolved a decade ago with Mr. Gitobu receiving damages of 15 million, the lapse of time justifies an upward adjustment of the award.
These are now the final orders. Arising from all that we have said, these are the orders that we make. 1, the prayer seeking to quash the resolution of the Senate to impeach His Excellency Gachagua is hereby declined. 2, a declaratory order is hereby issued that His Excellency Gachagua's fair trial rights were infringed when the Senate declined to allow an adjournment in the impeachment proceedings despite his absence. 3, a declaratory order is hereby issued affirming the constitutional necessity for Parliament to enact a dedicated statutory framework governing the impeachment of Deputy President under Article 150 of the Constitution. 4, the court makes no findings on pension and emoluments. The first petitioner is at liberty to pursue the matter before an appropriate forum. 5, the court awards constitutional damages of Kenya shillings 50 million to His Excellency Gachagua payable by the Senate to vindicate the Constitution, restore the dignity of the affected party, and deter future violations. 6, parties shall bear their own costs given the public nature of these proceedings. And lastly, for the avoidance of doubt, any prayer not expressly allowed herein is accordingly disallowed. Before we take leave of this matter, we wish to record our appreciation to all counsel who appeared in these proceedings and all parties for their industry, diligence, and the quality of their submissions. Your collective effort has contributed to the development of constitutional jurisprudence on this subject. We also extend our gratitude to the judiciary staff who worked tirelessly to support the bench in ensuring that this decision, the first of its kind under the Constitution 2010, was rendered in time. Thank you very much.
When her leadership, the Justice Dr. Mugambi, was reading part of the judgment, if I heard correctly, she said that the 10th respondent, UDA, filed written submissions on 28th August 2026. If my hearing is correct, then quite manifestly that is a typo that the court might wish to correct. Secondly, the first petitioner applies to have a copy of the judgment, one, and two, typed copies of the proceedings, and three, a complete set of the video recording of the proceedings. We would wish to have those as quickly as possible, of course, upon payment of the necessary court fees. It's a long judgment, and I am sure the first petitioner will want to be advised once we as counsel understand each of the issues addressed in the judgment. This honorable court has rendered its opinion, so there is nothing to be raised with this honorable court. But once we understand each issue by reading the judgment, the proceedings, and the video recording, we will then be in a position to advise the first petitioner, for example, on whether to pursue his other rights, as this court has indicated. I thank the court.
Thank you.
May it please you, my lords, my lady. Njeri Maina for the third petitioner. I wish to request for the typed certified proceedings and the certified judgment. And my lords, my lady, for the tidiness of the proceedings, I request on behalf of all other petitioners in this matter, the third petitioner has already filed their notice of appeal. We request that you expedite the proceedings and the judgment so that we can take it on from here. Thank you.
My Lord, my name is Degwa Njiru. I have sat here for approximately 10 hours listening to this judgment. I certainly have heard you clearly and the disposition. Equally, despite it being the judgment of the court, I do not agree with some of the issues that the court has deliberated and the conclusion the court has arrived at. And most importantly, my Lord, when we came before you, we only did not just come for judicial recommendations on legislations. We thought that, my Lord, will leave this court with a clear judgment on how a violation ought to be dealt with. When we came before you, my Lord, and we moved you, most importantly, on the issues of constitutionality of the manner in which the proceedings were conducted, we did not come here for a remedy of a legislation. It will not benefit my clients whatsoever. And for that reason, my Lord, and granted the dissatisfaction with your judgment, I have equally advised my clients, for the 4th, the 49 petitioners, to launch and prefer an appeal. For that reason, my Lord, would wish to be supplied with certified copies of the proceedings, the judgment, and the transcript. And for the reason, my Lord, that we need the transcript is that, my Lord, part of what was delivered by Justice Murima when he was deliberating on the issue of the plenary and the committee, I can tell you, I had never heard what he said and what he concluded. I therefore, my Lord, would wish to have the transcript provided in verbatim, so that, my Lord, we're able to deliberate and internalize them. We are otherwise not dissatisfied. We are otherwise dissatisfied, and we shall not watch when the Constitution is being buried. Thank you.
Your Lordships, my lady, my name is Kiragwa Dhuta for the 10th to 41st petitioners. And my Lord, I would like to request for the same materials that Senior Counsel Paul Mwita has requested for. Thank you, my Lord.
My lords, my lady, I do associate myself with the submissions of fellow counsels. My lord, there is a new twist into our constitutional declaration that we find a breach has been made, but then no outright remedy for that breach. My lord, if the Constitution has been breached, then clearly it means then the Senate where I sat and I followed the proceedings, it means that it didn't do its duty as required by the Constitution. So we wish to appeal and we wish to be supplied as quickly as possible. We pay. My name is Daniel Manzo for third interested party. We will wish to be supplied with all the necessary proceedings certified so that we could advise our clients appropriately. I thank you, my lord.
My lords and my lady, my name is Sakimpa. I do appear for the 4th to 8th petitioners. Your lordship, we do confirm that we've already received instructions from our clients to appeal, and we have since filed our notice of appeal, and we request for the typed proceedings to be urgently provided. Thank you.
My Lord, I'm equally instructed by Kibe Mungai to make the same application. He has equally instructed me to inform the court that it's important that we don't preside over the funeral of our Constitution.
My lords and my lady, I'm Phyllis Wangui Kamau, appearing for the 43rd petitioner, and I wish to associate myself with the submissions of Senator Manzo because the decision finds us in a constitutional absurdity. And for that reason, we do wish to appeal, and I join my sister, Honorable Njeri, and Senior Counsel Mwite to request for the type proceedings and the judgment. Thank you, my lords and my lady.
If it may please you, my lord, my lords and my lady, I'm Omanyi for the 57th petitioner. I think there was also a mistake with regards to the 57th petitioner. as the court was reading the judgment, it said that we had not filed our submissions and did not appear during the hearing, yet we appeared. So I think that is a mistake that the judgment and the court can correct the same. We also intend to file an appeal against this decision, and we request a copy of the judgment and proceedings, certified copies of the proceedings. Much obliged.
My Lord, my Lady, I find myself in a very inauspicious position. I commenced the proceedings, I closed. But my Lord, the reason is...
Excuse me, please respect the rights of the parties before the court. You are not before the court. Please sit down. Let's finish this matter or this file. If you have an issue with another file, we'll allow you to talk.
Okay, very well.
On behalf of the respondents, I presume we have no objection to the request for proceedings, and we have no request. We are waiting, my Lord, for the appropriate time to respond to the appeals, and so we will wait for them in the Court of Appeal. We are happy to do that. Thank you. Finally, my Lords, we just want to thank the court for delivering judgment. I think we've sat here for 9 hours from 12 to now. So we thank you for that, your patience. Thank you.
Mr. Kenyanjui.
Thank you very much, Your Lordship. My Lord and my Lady, I think I prefer them instead of bending.
Are you addressing us on this file or on another file?
This file.
This file, you are not a party.
It's because, my Lord, I addressed you.
We cannot mix issues.
Yes, we're not mixing. Because in this file, is implicated in civil application E291. All these petitions are part of E291. So the proceedings that commence these proceedings are relevant to my client. That's why, my Lord, I was making a similar application when I addressed the court. If I could get an audio transcript, if I cannot get the type, that's okay. I can get an audio. That is necessary for me before the Court of Appeal, so that I can show the Court of Appeal I brought to your lordships and my lady dependency of civil application E291 of 2026. That was limited to only that. Beyond that, I don't want to vex you. It's been a long day. So my request is for the transcript of the commencement of the proceedings up to the point that your lordship then directed that I shouldn't address you any further, because it implicates civil application E291 of 2026. I'm much obliged. Thank you.
Anything. He's a peace-loving Kenyan. He has called upon all his supporters to take whatever outcome of today's judgment, knowing that we shall proceed to the Court of Appeal and maintain peace and order so that we can give our institutions sufficient time to interrogate this judgment today.
How best, perhaps using very few words, would you describe the judgment? Using very few words.
Gravely disappointing. Gravely disappointing.
Thank you very much. Thank you. Any other counsel wants to speak to us, please?
All right, that there is Kirinyaga woman representative Njeri Maina, who was a petitioner in this particular matter, the consolidated petitions on the impeachment of former Deputy President Rigathi Gachagua. Nitazungumza na mawakili kidogo tu alafu nitakuita. So Yes, the court has ruled that the court has upheld the impeachment of Geoffrey Rigathi Gachagua as second deputy president of the Republic of Kenya, though the rider here, the court admits that the rights of Geoffrey Rigathi Gachagua were infringed, especially when the Senate proceeded to hear the matter without him when he particularly fell ill and was taken to hospital. But upon this recognition, the court says it has offered a remedy, and that remedy is 50 million shillings to be paid as damages payable by the Senate of the Republic of Kenya. But we have listened here to Njeri Maina, who is a petitioner and also a lawyer, stating that no, we will not be accepting these monies that have been offered. I'll bring it to you, Dan, but later, even as more counsel come out of the courtroom, we'll be getting